Hey, how you doing, Aaron?
Good morning, Greg. How are you?
Good. Hey, everybody. There's someone missing today. I think this is Chuck's first one he has missed.
Yeah, he's the one
He
who,
started
who
doing this.
really regularly is on the calls, and so he's getting a much deserved break right now.
Yeah, Chuck is sunning it up in Hawaii as the rest of the U.S. is under their snow and freeze and whatever tsunamis. Although there was a tsunami watch while he was there, but it was lifted pretty quickly. I thought he was going to have to head for the hills. Not necessary. Anyway, so we're here to talk about litigation, what we're working on. I will tell folks that we do not have that we're going to be ending a little bit early. Well, substantially early today because Aaron's got an interview, I guess, with government, and Chuck's not here, so we'll go through the cases, and also there's not a lot to update as far as changes in the last week, but so we'll do that, and then we'll see if there are questions on here. I have a feeling we're not going to have as many people as usual either attending because there's no Chuck. But anyway, Aaron, why don't we start with the K1 cases?
Yeah. So, in these cases, we within the last week or so, is when we filed the notices to the court of dismissal of approved plaintiffs. With that, we didn't just say for dismissal. We noted to the court a little bit of a nudge, as much of a nudge as you can do, saying the rest of our plaintiffs are still pursuing their case and are awaiting the court's decision on the motion to dismiss. And we're hoping that brings the case back onto the judge's radars, and that it might provoke a decision out of the courts. Once the case, assuming we survive the motion to dismiss, which we believe we will, then we are on to the next stage, which is a much better point of leverage for negotiations. And by negotiations, I mean getting your visas issued without having to go further, because at that point, there's either going to be a lot more work for the Department of Justice lawyers, or they can just pressure their colleagues at Department of State to issue the visas and avoid the work. So it's a good point.
Right. So we are, we're doing, this is about the limit of what we can do as far as as far as prodding these judges to move, but hopefully they're getting the message. We'll see. Okay. What is happening on the Go and Acker/Gomez cases? Any news on that?
Not since last week. So we had the status update in Gomez Acker, which had some eye-opening things in it, as far as why the government is saying it's so hard for them to produce visas from fiscal years 2020 and 2021. But the takeaway was they have to update their systems. They will not be updated until at least April of this year. And that's the earliest they could really start issuing visas for the visas that judges.
Well, that's what they said. We don't. I think that Curtis Morrison just posted something that showed that they did in fact managed to figure it out for at least one person on there. So it was technically possible to do it at least in one case with the software, but.
I think that's right. I think maybe that what they're saying is shorthand for they need to be able to track the visas. Yeah. So when they put them in, they might be able to physically print one, but they need to be able to show in their statistics which visas were for which fiscal years. It doesn't sound that hard to me, and probably less hard to you, Greg. But
all right. Well, in 90 days, supposedly they're going to start working on this. They also told the judge that they were busy approving DV 2022 cases and trying to get those out of the way before they got to the other ones, which of course is nonsense because they haven't approved any DV 2022s either. So that's I guess a good segue into what's happening with DV 2022.
Hold on, before you get there, just on the appeal piece of it, the appeals, the government still does not, as far as we know, have authorization from the higher ups at the Solicitor General's office to proceed with the appeal. So we are waiting for word on that. And yeah, now we can go into DV 2022.
Well, so speaking of that, on the appeal, I mean, I think my recollection is they have that weird and not helpful for our case rule regarding basically giving them as much time as the judge will take to issue a decision on the actually requesting an extension. So I guess they figure that they know that they've got a little time on that. So we'll see on that. But their deadline is whenever 7 days after, I guess, whenever the judges tell them that their deadline is that they're not getting an extension on that. Okay, DV 2022. So that case, we are onboarding, and hang on a second, Aaron. I know you had posted in the private link here. I gotta find it now. I'm not. Chuck's usually driving on this, so it's.
So while you look at that, I'll point out that.
That the case is onboarding. Here we go. Banner, create a banner. Here is the link to last week's YouTube on here. So write down that code at the end, and then you can watch the video that we did last week, which was an hour of talking about basically what that case is about and how it's going to work for those who are interested in potentially working on that case, participating in that one. We're steadily adding plaintiffs to that. We are also waiting data from the government to see where things are on that case. But that's really all there is to probably tell you at this point. We extended our deadline to sign up for the case, I think, by a week or two. I know Lily is happy. Lily is not happy. Lily is in the audience and can confirm that in the comments. So that is DV 2022. What about the H-1B case, the Liu case? What's happening with that one?
So this week, or I'm sorry, last Friday, I guess it was, we submitted the opposition of the motion to intervene, and that pushed back against. Hello, Lily.
Hi. Good morning.
Good morning. So that pushed back against the motion by a private company who wanted to intervene and defend the current regulation. Basically, our point is that it's very late in the litigation to be letting a new party in, and also their purported interests are already represented by the government, who is defending the regulation as stands.
I think their basically argument is we don't trust the government to stick with the arguments that they've already made. I mean, I guess it didn't really sort of like, it didn't seem like they were bringing something different than the government. So hopefully I think it's a delay tactic, honestly, that they are hopeful that it'll push this past March, which would leave this year's lottery in place. If I had to guess, sort of like what the thinking is on their part, is to buy some another year if they can get a delay of just a couple more weeks.
Yeah, I mean the one of the purported concerns was about the reputational concern, saying that there was so many allegations of fraud in our litigation, and that they didn't want it to be tarred by that. But our suit makes very specific allegations about fraud and includes evidence about fraud, and it's not to everybody. And the company that wants to intervene, IT Serve, was not mentioned, and so they weren't defamed, or there's nothing that's happening to their reputation. And so we'll see what the court wants to do. I mean, if the court lets them intervene, they let them intervene. The arguments still stand as they are, and so we'll see what the court wants to do. But our main point is that we want it to be resolved quickly, like Greg says.
And there was an interesting filing. I haven't had a chance to read it yet, but I just saw this morning that the defendants, the government, says that they also oppose the intervention. They don't want another party coming in and helping them. So that'll be interesting. See what arguments they're making and whether that influences the judge's reasoning on whether or not to allow them to participate. Intervene just means we want to be part of the lawsuit and have a chance to make our arguments as well, even though we weren't one of the original parties.
Yep. Okay. Aaron, what other cases do we want to talk about?
The EAD case.
Yeah. Okay.
That's King. The King opposition to the motion to dismiss and motion to transfer is busily being drafted and will be filed by the end of the week. And so that will be a major hurdle to overcome. If we can get past the motion to dismiss, which we believe that we will, we'll again be in a good position there.
Yeah, and in that case, that's one that there's a lot of possibilities for if the government wants to come to the table of ideas for policies and that could be adapted to settle that case. So we're kind of hopeful that if we can get past the motion to dismiss, that will be the point when the government will probably be more motivated to try and come to the table and settle it. Okay, Lily, any cases that I need to bring up that are not up here?
Have you talked about the fee lawsuit still accepting plaintiffs?
No, that's a good one. All right, so the fee lawsuit. Let's see, fee case. Here we go. Aaron and I were just talking about that beforehand. We can take some more plaintiffs for onboarding for that case, but basically the theory of that case is that there's actually two parts to it. One is people that paid for a service that they didn't get, or it was so delayed that it was useless to them. So I'm talking about F1s and J1s who paid CVIS fees that, if you were coming in for a J1 summer program and then you couldn't get an appointment before the summer started or even the summer was over, that would be an example of paying CVIS fees and paying visa filing fees and not getting anything for that. Or people that had appointments that were canceled and never had the government never offered a refund on that and never rescheduled them for new appointments, that kind of thing. That's part one. Part two is there's also based on research that one of our colleagues has done, we believe that the government has been overcharging for the non-immigrant visa fee for a number of years. And part of our class action is seeking to get a refund of that overcharge for all people who filed non-immigrant application fees. Even if you got the appointment, and even if you got the visa, you were still overcharged for that based on what the government is allowed to do. So that's that group of people. It doesn't even matter if you got the visa in a timely manner, and it doesn't matter if it was pre-COVID. It's basically, I think we're looking at anybody since 2016, because that's the statute of limitations. So if you're in that situation, Lily, do we have an onboarding page for that?
We do. I don't have it at the top of my
list,
but it should be on Impact. Let me triple check.
Right.
Onboarding cases. Yep, it is the second item here on
Impact.
Yeah,
just go to Impact Litigation if you want to participate in that. If you're in either group, we would be happy to have you. All right, so that is, I think that's the update on the cases. Aaron, we only have a couple of questions, so why don't we see if we can just do that?
Let's try to get through.
Okay. Let's see. When do you need it? When will DB 2020 start processing? 1 or 2 years? I think I'm sort of trying to decipher the question here, but
assuming that you're a plaintiff in one of the cases. If you're not, then DB 2020 is over for you. Is that right?
Well, I think they're different in each. DB 2020 and DB 2021 are different as far as whether you're a plaintiff or not. I think DB 2020 you have to be a plaintiff. I think you're right about that. DB 2021. It's not limited to the plaintiffs, or is it the
You have it flipped. So DV 2020 was certified as a class in Gomez. So as far as when those 9,000 some visas will start processing, it's what we talked about at the top. They say they can't until at least April, and so at some point after that, we don't really know yet, though.
Right. DV 2021, that was limited to the plaintiffs then. And in that case, there's a lot of them because I think our case only had a couple hundred, but the other case is like 27,000, and they're not in the same place, the two cases, because we've already had a summary judgment. In the other case, they haven't gotten actually a decision yet. And so we don't know how many people are going to be competing for the 9,000 that were reserved yet. Is that right?
That's correct. And there's also a little wrinkle in there that the case that is Rye, so there's Good Luck and associated cases, and then there's Go, and you have to be a plaintiff of some of those cases to get a reserved visa. In the case that is called Rye, RAI, you do not need to be a plaintiff of any case, but you have to be located within the Shenzhen area, I believe. So there is a possibility for people in some locations who are not plaintiffs that they could still get a DV 2021 visa, but I can't remember off the top of my head how many are reserved in Rye. It's not a ton.
Okay. All right. So it remains to be seen, but DV 2020, look for news in about 2 months. All right. Sonny is in Go and wants to has a question regarding whether we're going to consult a statistician to prove that Judge made his calculations were wrong on there.
It depends. We're gonna see whether the appeal is going forward. I don't know that it'll be a statistician that we use, but that's what we're going to be doing is working through the statistics and showing why we think his calculations are wrong. But I think more than that, there is some of that, but there's also the legal argument because what he tried to do is put Go plaintiffs in the same place he thinks they would have been had they administered the program lawfully from the beginning. And so what he thought he needed to do was reduce the number of reserved visas in order to make their chances not better than what they otherwise would have been. We argued to Judge Mehta that wasn't actually appropriate. That he should have just reserved at least visas for all of our remaining plaintiffs. And so we'll be making legal arguments as well as to why he needn't have made those calculations. So there's kind of two facets, and we'll take that as it comes.
Okay. All right. So in the lottery abuse case, do we have an idea about, from a timing perspective, when we have a February 15th is sort of, we've laid out and agreed on that's the date of the arguments, right?
Yeah, I think that's right. And we don't know when the judge will rule on intervention. I would assume he would rule at or before that hearing date, but there's no promise of that.
If he rules, will that change do you think that would change the date of they'll argue, if he lets them intervene, they'll argue that they should be able to delay the date, presumably to have time to prepare for it. Is that what's probably going to happen?
Possibly, although they submitted proposed memos and motions along with their motion to intervene. So we would argue that even if they're allowed to intervene, it shouldn't delay anything beyond us getting to respond to any arguments made in their motions or legal argument that weren't already responded to. So we would argue that it shouldn't delay anything.
Okay. All right. I'm not sure I understand this question. Any possibility to cancel it in case big numbers of plaintiffs?
What he's saying is, what I believe he's saying is, say we don't get a big number of plaintiffs, say we don't get, a minimum number of plaintiffs. Is there a chance that this?
We have enough to. I think that that's not going to be an issue. We're definitely going to proceed with the case on there. I hope we get more than we have right now, but it's one of these things that it's sort of like the later in the year it goes, the more panicky people are on there. So, but I'm guessing that also after we file the case, and we usually have an opportunity to add plaintiffs after filing, that we'll also continue to see. So I think we're going to be in good shape on that case. I'm not too worried.
Oh, I do too.
What do I think about these high CN that got their interview without being current?
So I don't know, Greg and Lily, if you saw this, did you?
Yeah, this is wild. I mean, I can't wait to see if a judge is going to understand how big a deal it is.
Yeah. So I mean, I think as people know that the Department of State says they schedule cases for interview in order of case number. We've seen in the past that that's not strictly true. But what's new and different about this is that they are scheduling and issuing visas that are apparently not even current on the visa bulletin, and that is wild. We've seen the screenshots of it, and it appears to be accurate. And if it is, it just adds fodder to the lawsuit about the lawless way that the program is being administered. So we'll definitely.
I mean, they can do interviews without case numbers being current. The visas themselves shouldn't be issued. They usually what they would do is just kind of hold up and just hold the file, and as soon as the State Department tells them they're current, they would just issue the visa at that point without having to redo the interview. Which is, which we want them to be interviewing people even if dates are not current, so that they can move as quickly as possible when they are. But it is a good example of sloppiness. All right. Are we aware of any employment-based adjustment EAD class action suits that one can join at this point for those who are waiting more than 6 months? So the Kang case, our case, we're not adding anybody at this point. I think we could after the motion to dismiss. I don't know if we have an opportunity at that point to add people.
So I wanted to address this one because it might have been this commenter, Alex, but it might have been some other people as well. I get contacted about this saying, well, if we're too late to get into Kang, can you represent us individually? And normally our answer is yes. I've been telling people actually that I'm not really comfortable with it because the courts really don't like when you are representing both a class or a proposed class and other individuals that would benefit from the class. And people who have been waiting over 6 months for an EAD based on AOS would benefit from the class if it's certified. And so I've been telling people that they should seek other counsel if they're wanting to.
Right, they can sue, but so the long and short of it is you can definitely sue individually. You just have to do that with another law firm than one of the three that are in this one. But and it's only the adjustment EADs. I guess in theory E2s, we have a couple of them in the case too.
Not in the amended complaint, so we could go forward on any other.
Or any other category other than adjustment of status EADs, like H4 EADs or anything like that. Any of our firms could work on. But so that's that's. Thank you for explaining to folks why that is a problem. All right. Can you do an EB2 adjustment of status on L2 as the principal applicant? Keep losing H-1B lotteries, but have an earlier priority date than my spouse. So the priority dates for, can you do an adjustment of status based on EB2 as L2 as a principal applicant? Do you guys understand this question?
I don't.
I think they're saying the person is an L2 now and their spouse is L1. And can the L2 derivative be the principal for the adjustment application?
Sure.
I don't see why not.
If they have their own I-140 and qualify in EB2, you don't have to be on an L1 you can be on any non-immigrant category and do an EB2, and adjust off of that with the other one. And it's actually fairly common where we see oftentimes couples where both are filing perms and both are filing I-140s, and then they'll file adjustments for each other on there. So I don't see a problem with what you've described. Always counsel on these kind of specific things to talk to your immigration lawyer, but you're not saying anything there that's making me think it's a problem. All right, we have a question on Chakrabarty. Are we going to file a new case? It's likely that we will. We will often, we'll take what we learned from Chakrabarty. We'll also see there are some attempts to try with other cases, I think, that are in the works to try and deal with the issue that came up in Chakrabarty that we think was just outrageous as far as like what happened with the at the last possible moment in that case. But yes, we are looking at that. We also obviously have to see what's happening with green card use, the statistics on there. So assuming that the same thing is happening this year, we will probably do it earlier, and whether we do it in Maryland or not is an open question right now. We may file that. There was a successful suit basically using our pleadings that our friend Barry Walker filed in Mississippi, and he was successful for 5 plaintiffs with the same arguments. So and that's a very conservative district. So, it's possible we could look at doing something like that, where we file cases in Texas and Nebraska, where we have we're not going to have the jurisdiction issues the same way, but it remains to be seen. But yes, we are looking at that suit for this year, but it's a little early right now. Question on premium processing. It's not really a litigation question, but I'll just mention that premium processing, the regulation is sitting at Office of Management and Budget as far as the allowing them to proceed with that. My guess is that will be in the next couple of weeks, released by OMB. I am making a prediction that we are going to see premium processing expansions in the spring. But I don't know if it's going to be all 765 categories, all 539 categories, or they're just going to pick and choose on there. But that should be coming soon. 765s and 539 should be the first processes that are available for premium processing based on what USCIS told us at the AL conference last summer. Okay. All right. So that's more on that question from before from Joe. Case number, you got your interview, and after that, your case number doesn't become current. Yeah, if your case number never becomes current, and that is a risk in a normal year, even if they are adjudicating everything in a timely manner, there is no guarantee that someone with a high case number is going to get a visa. Now, historically, most people get their visas even with high case numbers because the State Department lottery is such that they try and predict accurately how many they need to issue, how many lottery winners need to be selected in order to get all the numbers used and everybody being picked, but there's no guarantee on that. All right, we have one last question. Okay, can I clarify on that? Yeah, so if you are joining the suit for DV 2022, what we are trying to do is basically get you at least where you would be in a normal year that was non-COVID affected. I can tell you that, it depends. It depends on the year. Like in the Ocker case, all of our plaintiffs, even those with the highest case numbers, got their green cards, and that was the result of that particular court decision and the way the State Department went about it. With this Go decision, where they have 9,000 to basically just allocate as they deem reasonable, I don't know yet, in that case, whether people with the highest case numbers, how they're going to allocate and how they're going to issue. So that is a guarantee we will not make, that even if we win the case, that you will definitely get it. What you're trying to do in this case is be put in this situation you would have been in a normal year. You're not supposed to be, we're not trying to get people in a better situation than just any person who applied for the lottery in a normal year on here. We're just trying to get you back to the place, basically get you back to 2019.
Although, if we have an outcome where the judge reserves visas for plaintiffs only, then you likely will be in a better position, right? We're not promising that that's what will happen.
But that's right. So if we get a DV 2020 year, then that would be fine. If we get but there are no guarantees in litigation, and if you insist on a guarantee, then probably this is not the case for you. Okay. Lily, somebody's saying that the FAQ needs to be updated on the extension of the deadline on that. So we'll take a look at that, and if there's someplace in there we need to update, we will.
Okay, I think Kirby updated that, but I'll check through and make sure it's updated throughout. Is it on the FAQ?
I will promise you, if you do the onboarding, you will still be able to get in. So that is Lily and I have the power to make that happen. All right, so that's it. Aaron has to go and represent his client and go do his work. And I have it on my calendar that in 90 minutes I will see you guys again and answer some more questions. If you want to come back, that will be on our Facebook and on my Twitter feed. So everybody have a good rest of the week. And is Chuck coming back, or is he gone next week too? He may be gone next week too. He's taking a good long trip. Hopefully, he needs it. All right, guys. We'll see you next time.
Thanks, Greg. Thanks, Lily. Thanks.